Friday, the 18th day of August 2017. Good morning and welcome to Citizen Extra, your premier show for all matters politics, current affairs, business, sports, and even technology. My name is Wahiga Mwaura. Now, coming up on Citizen Extra, all eyes on the Supreme Court as their registry will be open for the next 16 hours or so to give ample time for the filing of presidential election petitions. We'll keep monitoring that situation and update you as soon as we have any developments, especially in regard to NASA leader Raila Odinga's petition. Meanwhile, we continue monitoring the counties where today Muranga's Mwangi Wairia and Kajiado's Joseph Olelenko will be sworn into office among other governors. Our reporters on location in those counties will shortly give us more details about those inauguration ceremonies. Elsewhere, Google the word Kenya and a plethora of headlines from international media outlets will jump at you regarding last week's election. So, what does the world really think about East Africa's top democracy? We'll look at those headlines and discuss the implications in the course of this broadcast. And finally, as governors continue to take their oaths of office over the next few days, they'll have to contend with reconstituted county assemblies that are meant to keep them accountable. But what lessons have MCAs learned over the last 4.5 years, and can they shed their negative tags over the next 5 years? We'll discuss those issues with some members of county assemblies later in this broadcast. We also have the latest news on the local and international arena as well, and we'll be crossing over to some of those counties we spoke about, Kajiado and Muranga as well, and be telling you what's happening in regards to the inauguration ceremonies. As soon as we can get our reporters there, we will have updates. But talking about the presidential petition, that's the big topic of the day, because we know that according to the presidential election petition rules, a petitioner is required to serve the respondent within 2 days of filing. That filing must happen today because the deadline is today. Now, to talk a bit about this, the grueling process of a presidential petition, I'm joined by advocates Kibe Mongai, Boniface Akusala, and Apollo Mboya rather. And what they'll help us do is to quote-unquote deconstruct this whole process and make it as simple as possible. And what we hope that what you at home are doing as you continue watching this program is that you'll be SMSing us on 22422 and letting us know what you think. If you have any questions about the process, the filing of the petition, the hearing of the case, and the determination as well, then SMS us on 22422. Talk to us on Twitter as well, at Citizen TV Kenya, and let us know what your thoughts are. And any questions, my panel in studio will help us to go through them. But today we're going through what I'm calling Presidential Petition 101, going back to school, and I've got my whiteboard here next to me, and I've got my panel ready to educate and update us on the latest in regard to that as well. Now we've broken down the process of presidential petitions into 4 stages. The first stage is the filing of the petition, which is expected to happen today. How does that happen? And I want to ask Kibe Mongai now to step up to the front here and just give us a little bit about what you can expect in regards to the filing of the presidential petition. Kibe, you may have the floor now briefly, of course, and I'll give you your marker here. Kindly come and join us over here and just walk us through. Karibu sana. You are in our mock court of law for today. Here you go. Right. Just a few ways in which you can help Kenyans just to briefly understand this process. What are some of the things we can expect? And maybe I can even guide you. What are the steps in filing a petition?
One would say like there are several steps.
Okay.
The first one is you decide the right to file the petition.
Okay.
First of all, there must be a declaration.
Okay.
That has been made on who is a president-elect.
Okay.
This was made last Friday.
Okay.
By the IEBC.
Okay.
Declaring President Uhuru Kenyatta has been re-elected.
Okay.
And
in fact, let me do this. Let me help you. Why don't you stand on that? Come and stand on this side. Okay. So you say step number 1, right to file a petition. How can we break this down for those who are watching at home?
Precisely. Okay. The right to file a petition.
Okay. Forgive me for my handwriting.
Yes.
Okay. Right to file the petition.
The petition.
Okay. All right.
Is by either a voter.
Okay. Okay. So any voter at home can decide.
Yes, or a candidate.
Or a candidate.
Or a candidate in the election.
Okay. Keep going. Keep going. I'm keeping up.
This arises. The issue of filing a petition arises because of a declaration that has been made by the IEBC.
Yes.
That is a president-elect.
Okay.
This declaration for purposes of this year was made last Friday.
Yes.
By the chairman of IEBC.
Yes.
Mr. Chebukati. Now, 7 days, the law requires that any person intending to file an election petition to challenge that declaration is supposed to do so within 7 days.
Okay. Okay.
Those 7 days are lapsing today.
Okay.
Yeah.
All right. Keep going.
So today we expect that as NASA leaders said that they are going to file this petition.
Okay.
And they have up to midnight of today to do that. This petition, as the regulations say, is filed when you pay the court fees, which is 500,000 shillings.
Can you walk us through those court fees just for the benefit?
Okay. The court fees for purposes of filing the petition is 500,000.
Okay, 500,000. Okay.
And you also deposit a security.
So the court itself is like a
cost. Yes, it's like
500,000.
500,000.
And then a security.
A security for 1 million. Security against cost.
Okay. Do you get your security money back after, or is it non-refundable?
It depends on what the court says. The court can dismiss or allow a petition on the basis of they can award cost, or they can say the costs are not going to be awarded.
Okay.
If the court says that it is not going to award cost, then it would mean that this security, 1 million shillings, would be refunded to either the person who, the petitioner.
Okay, I see.
Yes.
Are there any other little costs here and there?
There are other little costs here and there. For example, the respondents, there is some money they're supposed to pay. I think it is 20 million. When you're filing submissions, there is certain amount of money you pay that is assessed on the basis of the number of pages that the documents consist of.
Okay.
But those are not the bulk of the cost. The main costs are the court fees for filing the petition, of course the response, and the security that a petitioner pays.
So anyone going to court today needs a minimum of 1.5 million.
1.5 shillings at minimum.
Million Kenya shillings.
Precisely.
Okay. Finally, because we'll need to carry on and take a look at some of the other processes, if I am going to court today, what am I carrying? What sort of documentation am I carrying? Are there any standard forms that I must have filled in? And what must accompany those forms?
Yes, there are two issues that you are supposed to go with.
Okay.
The key issue is that the document is called the petition.
There's a document called
the petition.
Okay, the petition.
In the petition, is where, for example, you will say that you are challenging an elections conducted on this particular day.
Yes.
And in that election, these were the candidates.
Okay.
And this was the results.
Okay.
And this is the declared winner in the result.
Okay.
So you contain that. Then in the same documents called the petitions, you state why you are challenging the petitions, and you also say the grounds upon which you want your petitions to be allowed.
Is this a standard form? Or is it you who generates it? So different, if two petitioners go to court today, will their forms look the same, or will they have different formats?
It actually depends on the grounds. So that is what probably, you see people may have different grounds. The petition will basically have the same normal outline. Like they say, you can say, our man looks like. Okay. There is a general way, our man looks like or a woman. Okay. But now, there of course, one is dark, one is brown, all these issues goes into the issue. Okay. And that all depends at the end of the day on what are the grounds upon which somebody is challenging the election. Okay. And the ones that are given by the law, for example, would be the validity of the presidential elections. Okay. And questions about whether these elections complied with the law, they largely revolve around IEBC. Okay. Did IEBC at the polling station, was there peace? Did people vote correctly? Okay. Was anybody prevented from voting? Were the votes counted properly? Yes. Were they tallied properly? Okay, and transmitted properly. Okay. All this now goes into the issue of validity of the election. Okay. There can also be the second issue, the qualifications of the president-elect. Okay. This year I don't think there was much of the qualifications, but the law says who is qualified to be president. Yeah. So if there's any controversy, you can put it in the petition. Okay. Then there is also the questions of whether an election offense was committed. An election offense could be bribery, it could be undue influence, it could be intimidation, it could be use of violence. So all those are issues that will be tackled in this petition. Okay. And of course there is the questions of the validity of the nomination. Was the president validly nominated by his political party or not? So these are the instances of the grounds. And of course there is the extra issue that any other sufficient reason. That, for example, could be I've had, for example, the issue of hacking. Was there hacking? And how did it...
so there need to be a section on hacking, quote unquote.
Yes, if you have taken it as an issue.
Okay.
But now after the petition, the other key documents that is supposed to be there is a document called an affidavit. It is in this affidavit, in support of the petitions, where you say what is your evidence. And by evidence now it would mean, if in Kamukunji constituency, for example, you are saying that the elections was not held in accordance with the law, then what would be required is to say there were these, either our agents did not fill these forms, the results that ultimately was relied upon by the commissions to declare the results is not genuine. The one that was recorded in the respective polling station. So this is now, you will have now to put the evidence of that in your affidavit. If there is some disputed Form 34A or 34B, that would be now your time to include them. If you are saying there was hacking, then it would be required, you need to come up with an affidavit of the specialist, for example, who is saying there was hacking, and he gives proof of how this hacking took place.
I'll need to stop you there, because there's another part that we need to tackle as well. What I want to give your fellow learned friends 30 seconds each to comment on this process. What more can you add to this, Kusala or Boya?
I think my learned colleague has tackled most of those issues properly. Perhaps the only other issue that I would like to perhaps point out is there are provisions as to presentation of witness statements. When there is, for example, the expert evidence, it can be produced by way of witness statements. And the witness statements would be part of the documentation? That is part of the documentation available. Witness statements. Keep talking. Yes. And as well, you see the documentation that you're talking about? Yes. It is in several formats. There is, of course, the petition, there is the affidavit, there are these statements. Then, you see, there is now the evidence. For example, the forms themselves, the hard copies, in case there is any variance between 34A, 34B, and 34C, those disputed forms must be included so that the court can be well advised. Yes. Thank you. And for you?
Yes, I think at this stage also, the registry plays a very critical part. The registry checks. This is the Supreme Court registry where you're going to file,
which is open today, I think, until midnight.
Yes. They check that all the documentation required for the petition have been properly filed, and if there is anything missing, they can actually alert you. Yes, they can alert the petitioner
and give you, and hopefully you'll have enough time to go. Collect what is missing.
Yes, so long as you beat the deadline of midnight tonight, because it has to be 7 days. Another issue is that when we are talking about witness statements, parties then must be very sure that the person that is going to be included in that affidavit as giving a specialized rendition on a particular issue, for example, ICT issue, is somebody who is qualified and cannot, his qualification cannot be impeached. Because that's an issue that can arise there. And lastly, there is the aspects of election offences. We have an Election Offences Act. So apart from the actual voting, which my learned colleague has talked about, there could have been other issues before the voting day, during the campaigns, all the offences within the Election Act, including advertisement, use of public resources to campaign, can be actually contained as part of the evidence that is being
so that might also fit in whatever petition into. Good. So for those of you who just joined us, we're just talking about filing the presidential petition, which we expect that to happen today. We're not sure how many petitioners will go to the Supreme Court, but what we know is that a voter, a candidate, you have the right to file your petition. We know that filing must take place within 7 days, and today is the deadline, midnight. We know that there are certain expectations in terms of, if you're sitting at home and you're thinking, I also want to file a petition, you need at least 1.5 million Kenya shillings minimum to be able to do that. And that is, you need the cost of the court and a security which might be deducted should you be fined. If I'm getting that, should the court charge you, that to deduct from that?
Should your petition be dismissed?
Or should your petition be dismissed?
Yes.
But you've also told me you might be lucky that part of this might be refunded to you, this 1 million.
Yes, for example, the court might dismiss your petition, but still go on to say that it will, because the cost depends on the court.
It is true.
The court can say you don't have to pay for this, that it was an important public interest matter.
Okay.
So that ultimately depends on the court.
Good. And finally, we've talked about what we expect in terms of the documentation that will be presented before the Supreme Court. We've talked about the petition itself. You need to swear an affidavit, witness statements. If there was any contravention of the Election Offences Act, that can also come into this particular section as well. I'm going to catch up on my legal jargon here, but I hope am I a good student? I hope so. Kibe, I'll allow you to sit down now, because at least I hope for those at home, and of course, if you have any questions, 22422 SMS us. Kibe will give you a chance to answer some of them. I can allow you to sit down now.
What Kibe did not tell you, is that 1.5 is minus the cost for the lawyers, the fees.
Oh, there's also a cost for the lawyers. Maybe at the end I'll ask you what, how well have lawyers done in this season. But there's a cost for the lawyers as well. My goodness, my goodness. Apollo, I can see you're bullying Kibe. So let's turn this round now. Let me call Councillor Kusala to come forward. He will be telling us about what next. So let's say a petition is filed today. What can we expect over the next 4 to 6 days? And I'll call this particular section serving the respondents. But of course, there's more to that. Let me just key this in. There we go. Not key it in, rather write it down. There we go. The ball is in your court.
Yes. The next process after, of course, filing the petition is service. First of all, I must admit that it is the easier of the two.
Okay.
Doing the petition is quite Herculean. You see, you are alleging, and you need now the court to be convinced that it needs to overturn the decision that was arrived at.
Okay.
So, the response is usually served upon the person against
also feel free to face the camera. Yes.
Against the person who the petition has challenged. For example, there is the IEBC.
Okay.
There is the Jubilee Party.
So hypothetically, let's say NASA files a petition today. Who do you expect them to be asked to serve once they file that petition?
Definitely IEBC.
So let's say they might serve the.
They will definitely serve the IEBC.
Okay.
They will serve the Jubilee Party.
Okay.
If they are the respondents. Now these are respondents.
Might they, some have felt that they might serve the president and his deputy?
That is also an option available to them.
Okay.
The president and his deputy.
Okay.
And the mode of service, unlike other pleadings, the mode of service usually is not just personal. Because if you look at the other civil procedures, service is personal unless court gives leave that someone can serve.
And in fact, I need to let you know, because we're displaying this on the screen, I just want to let all Kenyans know that these are potential scenarios. It has not happened yet, so do not, we are just looking at potential scenarios as well, just for your benefit. Keep going.
Yes, so service is personal. Service can also be by way of newspapers of national circulation.
Okay.
It's, of course, due to the sensitive nature of election petitions, respondents may disappear.
So that has happened in the past, right?
It has happened. In fact, I remember in 2013, we intended to serve an MCA. He saw us and took off. So it was impossible to serve him personally. Therefore, that is why the law now provides that service can be done by way of newspapers, not just newspapers, but of national circulation.
So right now, if you put an advert in the paper serving someone, it is considered done.
It's effectively, that person has been served. If that newspaper is of national circulation.
Okay, newspaper of national circulation.
Yes, so that is basically what happens. Now, the response is in the form. There are some forms that have been issued, Form B and C, within the rules of presidential petitions.
Oh, so now you're taking us away from 34A, 34B to a new series of forms.
Yes, there are forms. For instance, the law, according to the rules, provides that the petition shall be in the form of Form A.
Okay.
But now,
so the petition,
shall take the form of Form A.
Petition Form A. Okay.
Then the response shall be in the form of Form number B.
Okay, Form B.
And then there is yet another response. This Form B is where the response is defending the petition.
Okay.
But there comes a time when the respondent does not want to defend. For instance, if you are serving Jubilee Party and Jubilee Party is not interested in defending it, it may raise a response in the form of Form C, which is a response not to defend.
Response not to defend.
Yes.
Okay.
So that now they are stating we are not taking part in the proceedings.
Okay. I'm asking our viewers to forgive my handwriting. It is not the easiest thing to write on. So let's play examples.
Yes.
So the petitioner in this case could be NASA.
Yes.
They will present part of the documentation will be Form A.
Okay.
And if they serve the IBC's response will be Form B. And then if they also serve Jubilee Party, and Jubilee Party are not interested,
yes,
their response not to defend,
yes,
will
Form
be
C.
Form C.
However, this is just a skeleton. The way lawyers have, and I agree with my learned senior, Mr. Kibe, the way lawyers draft, they may just take this as a house, as a casing, but basically it will follow the format, but the contents will be different.
Okay.
Yes.
Finally, before I let you go,
yes,
the petition is due, deadline is tonight.
Yes.
The response, does it also have a timeline?
The petition having been filed,
yes,
first of all, the time of responding is you need to serve within 2 days.
Okay.
Yes.
Or serve within 2. So there's another step here.
Yes.
Called service.
Service,
which is 2 days.
Yes.
Okay.
2 days after filing.
So if NASA filed today,
yes,
then they need to serve, let's say IBC by what date?
By Sunday.
By Sunday.
Yes.
Okay.
Now, interestingly, if there are several other petitions that had been filed,
yes,
the response shall be needed, which the response, of course, my learned senior will talk about the response,
yes,
but the response will be served as at the date of the last petition that was filed.
Okay, okay.
Yes.
So if the last petition was filed today,
then the response shall be required now, period running from today.
Okay.
Not from the first petition that was filed.
Just in case somebody
yes,
filed on Monday.
Yes.
Okay.
Yes, that's
okay.
correct.
So so the service is within 2 days.
Yes.
So let's say if I'm the IBC,
yes,
I've been served on Sunday. How many days do I have to give a response?
You have 4 days.
I have 4 days.
Yes.
Okay. So let's break that down. That's when Thursday.
That is.
Is it Thursday?
4 days. You serve within 2 days.
So Sunday,
they have 4 days to respond.
Yes.
Okay. So by Thursday,
do the math.
IBC
I'm sure he does not
should have
do the
responded. And of course, even the Form C, if you choose not to defend,
yes,
then you also have
within the same period.
The same period.
Yes. Now you will discover that there may be several petitioners.
Okay.
And therefore several petitions.
Yes.
The respondent may choose to defend a petition or choose not to defend another petition. Okay. So that is also another option available.
Ah, okay.
Yes.
Okay, I see. Good, good. A brief comment, 30 seconds from both of you, if you have any. If not,
it's good enough.
No. Good enough?
It's good, good.
He has broken it down properly?
Yeah.
I'll give you a chance to sit down. Of course,
perhaps the only thing,
go ahead.
The cost of this response from B is 20,000.
Okay.
And this response to not defend is 4,000. So basically the cost.
So it's cheaper to...
Yeah, it's easier. 4,000 shillings.
So it's easier to choose a response not to defend,
yes,
which is Form C.
Yes.
Good. I think that has come out nicely. Of course, I'm waiting for questions from our viewers, and we'll be able to, we might be forced to revisit some of this. Apollo, let me now call you forward to come and tell us a little bit about hearing of the petition. This being a very crucial stage, because that is when the evidence will be presented, and all the stages in that as well. Hearing of
the petition.
I'll ask you to try and favor the camera.
Yes.
That camera for the benefit of our audience. Go ahead.
Now, once the filing has been done,
yes,
the first thing that will happen, the first court session, will be what we call conferencing.
Okay.
Yes. So of the parties. Okay.
Okay. Keep talking.
The conferencing is a housekeeping method, whereby the judges and all the parties are in court, and everybody is trying to check the documentation. If there is any complaint that they have not been able to access particular documentation, then it can be raised there, and then the court can give directions on how to obtain.
Something what they call pre-trial. Is there any link with what they call a pre-trial conference?
Yes, you can call it pre-trial conference.
Okay.
Yes.
Okay.
Yeah.
Keep going.
Yeah. Something that we needed to have said is that upon declaration of results, IEBC are supposed to deposit all the forms with the registrar.
Okay.
Of the judiciary.
In this case, let's be specific.
Yeah.
Which forms are we talking about?
We are talking about forms in which form 34C.
Okay.
The Gazette.
Even 34A and B as well?
Yes.
Okay.
They are also supposed to be deposited there. This was an amendment that was occasioned in the Election Amendment Act because it was found that any person who wanted to file a petition was having problems with obtaining this, and it delayed. So there were certain forms, all the evidence leading to that declaration of results are supposed to be deposited with the registrar, so that any person who wants to file a petition just goes there and obtains the documentation.
I don't know if you mentioned, is there a timeline? Should IBC have deposited by a particular day?
Yes.
What does immediately mean, or soon? You know, you need to, soon could be next year.
Actually, if like they declared on Friday night.
Yes.
Okay. By Saturday, this should have deposited.
Okay.
With the registrar.
Okay.
Yes.
Okay. That's important to know. So, conferencing of the parties. Is there a date? So, if what date can we give this particular?
Basically, now you are in the hands of the judges.
Okay.
Now the judges are the ones now controlling all the timelines.
Okay.
At this time, they're saying, okay, you don't have this documentation, can you supply? And as Advocate Alusala has said, there could be other parties also who have filed petition.
Yes.
So they'll be saying, no, we have not been served with the other petition. We also want to be served.
Yes.
Then the judges will give direction on the service between the parties and all other housekeeping, and then give the date when the submissions would have been filed.
Okay.
And then the hearing starts. They even give the time.
Okay.
Yes.
I assume this conference of parties is one day.
Yes.
And then after that, the Supreme Court judges will give the way forward, set dates.
Yes.
And things like that.
Correct.
Okay.
Yes.
Talk to us about the hearing now.
At the hearing, the judges, I suppose, because first of all, the parties will appoint their lead counsel.
Okay.
I think it's very important.
Okay.
There could be a battery of teams, of lawyers per team.
Okay.
But not everybody talks in court.
That is correct.
Yes.
That is correct.
So, ideally, the teams who will appoint their lead counsel, who will be articulating the issues. Now, the lead counsel can also then decide, or the teams can decide that on a specific aspect, another member of the team is the one who is going to talk about
who is best versed with.
Yes, for example, it could be ICT.
Yes.
Yeah, as Kibe maybe has expertise on that ICT, in addition to being an advocate, then is the one to urge that point.
Okay.
So they can do that.
And that is why we've seen different lawyers tackling different aspects. For one, either for the petitioner or for the respondent.
Correct.
Yeah, okay.
Yes, but ideally the judges then will give timings. It's very key. In the conferencing, they can decide that they will ask the parties, how long do you intend to take, okay, to urge the petition, for example. How long do you intend to respond to that, okay? So they will be giving timing, and that's part of the housekeeping, so that they know by this date all the hearings are done.
Okay.
Then now, after the hearings are done, then they will retreat to now consider the evidence that has been placed before them, consider the law, and then give the judgment within 14 days from the date it was first filed. So it's very rapid.
Okay.
Yes.
And after that, the Supreme Court judges,
yes.
I'll just use the SCORK, Supreme Court of the Republic of Kenya, will retreat.
Yes, they'll retreat now, the judges now,
and
to consider all the evidence that has been placed before them.
Okay.
Okay. And write their judgment.
Okay.
Yes.
I have got this. And write their judgment.
Yes.
Okay. What sort of, in the documentation, are there specifics? For example, are you told that you can only submit documentation of a particular amount? Is there specifications like the font type and things like that? What will be discussed in this hearing? Are there any specifications? Or
yes. Ideally, the font has been given. It's 14.
Size 14.
Yeah.
Okay.
Times New Roman. But
Times New Roman.
Yes.
Okay.
And you'll find that also at the time of trying to introduce, during the hearing, a party can try to introduce new evidence at that time.
Yes.
And the other side can actually object.
Okay.
So if you want to introduce a new evidence, then you must ask leave of the court.
Wow.
Yes.
And all this still needs to fall within that 14-day period.
Exactly. Because you cannot just, once you filed your documents, any new document that now you want to introduce, you must get the leave of the court first. Otherwise, it will not be considered as part of the evidence.
Okay, let me allow both of you to come in. Go ahead, keep it.
Yes.
And leave means?
In simple language, it means permission.
Okay.
You need to get the permission of the court to introduce any new evidence.
Okay.
But it is important to point out that because of the serious time limitations, for example, the pre-trial conference, I think they have already scheduled it that it will take place next Friday.
What date is that? Potentially Friday.
Yes.
Yes. That would be
25th.
Friday 25th. Yes.
25th of August.
Yes. Okay.
And remember now, Friday, that would be the 7th day.
Wow.
Yes. So that a ruling must be given by the end of the 14th day. So that on Friday, it is expected all the documentation for purposes of evidence would have been filed.
Yes.
The reason why they talk about the permission of the court to file any new evidence is because if any issue that is known as of now, or you ought to be aware of it, you must include it in your documents. So the only new issue that you can introduce is, for example, something after you filed your documents, some new evidence comes up that probably it was not possible for you to have introduced it at the time when you are filing your documents. But it's also important that, though my learned colleague spoke about the reference to witness statements, the actual rules of the Supreme Court do not refer to witness statements. Witness statements ordinarily are used like in the other elections, where it is expected that a witness will come to testify. But the hearing in presidential petitions is by way of affidavit. So in your affidavit, you include all the evidence, including an affidavit by the expert. Because the expert will not actually appear in court to give his testimony.
So the affidavit will play.
And therefore, the way in which normal court sessions are conducted, where you see a witness come to give some evidence and questions are asked, because of the pressure of time, that does not take place in the Supreme Court. So it is important to know that. And this hearing, it is likely to start, in my estimation, on Sunday next week.
Okay, that is Sunday the 27th.
Sunday the 27th.
Okay.
In all probability.
Sunday, and Apollo seems to be agreeing with you. When lawyers agree, I think I can take that one.
No, it's true. They'll be trying to avoid Saturday. Because of the Chief Justice, I know.
It's not so much the Chief Justice, it's because of submission.
But to give time.
You know, during the pre-trial conference is when directions for filing of submissions will be taken. Chances are that it may not even be Sunday but Monday. Because the petitioners may be given time to do it by end of Saturday. Then the respondents, that is also answering to the petition, will be given up to end of Sunday. So that the actual date for hearing is likely to be Monday. Monday is likely to be
Monday the 28th.
Monday the 28th.
Okay. I'm coming to you in 1 minute. Let me just engage Apollo here on one issue. What are the potential ways in which a Supreme Court can rule? Okay, so for us at home it looks like it's either this way or that way. But can a Supreme Court go more ways than anticipated in terms of how they rule?
Of course. You see, the main issue is the presidential election petition.
Yes.
And the question is whether that elections was conducted in accordance with the law.
Yes.
Whether it was free, fair, transparent, credible, and there is one aspect, verifiable. You know, those words have been used in the Constitution.
Yes.
Verify. Can you verify?
Okay.
Yeah. So verifiability will be key.
So it sounds like more of quantifying your evidence.
And that's why the forms that my learned colleagues talked about are very critical. How do you verify? If I give you a figure, how do you verify that figure?
Okay.
This forms helps you. But in giving its decision, the Supreme Court can also give certain observations that go towards improving future elections.
Okay, that's good. Let me stop you there. Akusala, you can come in now.
Yes. There is an issue that you have raised about the Chief Justice. Not actually, quorum for the Supreme Court is five judges.
Okay.
Therefore, whether the Chief Justice is available to sit or not, it may not affect quorum.
Okay, so that's interesting. So quorum for the Supreme Court is 5.
And currently has 7 members.
5, and of course, currently has 7 members. So
one or two,
if 1 or 2 are not available,
the process
still continues.
Yes, but like the Bible says, I believe if a hearing was had to be conducted on Saturday, this is one issue. I'm sure the Chief Justice would create an exemption and he would attend court.
Well, he's not here to answer you. I believe we're going to leave that matter at that.
No, they're right. They're right what they're saying.
And again, I don't want us to take discussing whether or not they're sit because of go ahead.
I want to talk to you about the quorum.
Okay.
This quorum, what my colleague has said is that's the position. 5 judges to hear a matter. But there could be spanner in the works. For example, if a party asks for recusal of particular ones, you see, it can destabilize. So there are 7, the minimum is 5, Ideally, and we all agree, ideally they should all sit. 7. Ideally.
That's best scenario.
Best case scenario. But it is also, there's a potential that we could only have 5 for one reason or the other, including recusal.
Let's take a look at what people are asking us here. 2242, of course, they want to engage you here. Can the court refuse the petition? You don't tell us your name or where you're texting us from. Can a court refuse a petition?
No, as long as there is proof that that there is a petition in the standard form that is provided, and you are a Kenyan, of course. In the sense of being a voter or being a candidate,
so if
you have paid.
If you are neither voter nor
candidate, you have met all the qualifications,
then you cannot present a petition.
Yes, in my view, like a company, you can't present a petition.
Or if you're a foreigner living in Kenya who feels aggrieved,
because it's a political issue. Political rights are only enjoyed by Kenyans. That's an exclusive right under the Constitution.
Yes. The courts may not really refuse a petition if it has been filed within the thresholds of law. However, you'll find at times the petition has been filed out of time, the court will refuse it. Or at times it has not met the thresholds of law, the court will refuse it. Otherwise, if it meets them, there is no way court will refuse.
So if it meets the criteria, technically it cannot be refused. Another one here who has deviated a bit. What is the deadline to file a petition for other political seats, such as Member of Parliament? Are there any?
This is 28 days from the time of the declarations. And most of these declarations were made on Thursday and Friday last week.
Yes.
So it's 28 days.
28 days from that.
And those are had in lower courts.
Yes. The High Court.
High Court hears the governor, the women rep and MPs. It is only the MCA's case that are heard by the magistrates.
Another person here, but they're asking more of a political question than a legal question. Let me see if there's any other. Meanwhile, let me engage you on something here. Has an African Supreme Court overturned a presidential petition or election or declaration? That's a question many are asking. I know you might not have followed all African countries, but has that happened in Africa yet?
Yes, precisely. I am not aware of where this has taken place in Africa, but the reasons could also be various, as in the sense that, for example, in Tanzania, you don't even petition go to court to challenge any elections. They have a funny system where, unlike Kenya, you don't even have the right to go to court in a matter to do with the elections. Of course, the one of Museveni has severally, at least on 2 occasions I'm aware, it has been challenged, but they did not succeed. But the important issue for me, to answering that question, you as a lawyer, the party you don't want to represent under the Kenya's electoral rules is actually the petitioner. Because you see the time that we are talking about, 7 days, it is highly unlikely that within 7 days you would have done as good a job as you would have intended to do.
Yes.
And the fact that even when the hearing of this one, as I told you, it is where you use affidavit evidence. And in an affidavit evidence, you will make an accusation, somebody else will make an accusation. For example, for purposes of a station, you might say that somewhere in Kipipiri constituency, that the vote that was declared was more than the actual number of people who voted. Now, if you make that in an allegation in an affidavit, and there is a counter allegation saying that the right thing was done, in the normal scheme of things, how you would have resolved that problem is actually to say go and recount those particular votes. Unfortunately, this is not possible in a presidential petition, and therefore you actually start from a point of disadvantage under the current rules that you are having for a presidential petition. But the irony of the matter is this, that when this issue has been arising amongst all the political actors, they assume that it is not them who will be petitioning, that it is the other side. So they are aware the rules are unfair, and there is actually a mountain to climb for a petitioner to be able to win under these rules.
Let me stop you there. Apollo, I'll keep reminding you to favor the camera. So some of our viewers are asking us to paint scenarios. One scenario is if the petitioner wins, in this case, a lot of assumption is happening here. Remember, of course, for our viewers at home, what we're discussing here are things that have not yet happened. We are trying to play out particular scenarios just to make it easier, but none of this has happened as of yet. But let's say hypothetically today, and I'll start with you, Apollo, what are the implications of the way forward? Should the court, quote-unquote, rule in favor of the petitioner, which we assume will be NASA, or the other scenario, should the court rule in favor of the respondents, which in this case would be IBC, stroke Jubilee Party, stroke the president or his deputy? So maybe you pick one and I'll allow Akisara
let me pick
another scenario.
Now, in such a situation where the petition succeeds, that's what we normally, how we say it, then another new election will be organized to take place within 60 days.
I like the way you've answered that.
And it's in Article 140 of the Constitution.
Akusala, you can come in on this one. Should the respondents get their way in court, IBC, Jubilee Party, the president or the deputy, what's the way forward? The court rule in their favor.
Status quo. Now what will happen is swearing in shall now be slated, because basically it will be treated as though that is the date of the declaration. From that time till the time of swearing in.
So you almost had two declaration dates, the one by the IBC and then of course finally when the Supreme Court
now when it goes to the Supreme Court, it is pushed forward. So that this matter is heard within the 14 days, and then after the judgment has been done, there is now the time frame within which
I know we're just about to take a break. Before we do, let's talk about the 14 days. Are you gentlemen happy with that time period? Should we have worked on amending that 14-day period over the last 4.5 years or so? Or was it a big mistake to allow them to remain as they are? Because of course it will affect how effective this whole process can be. At least that's in my opinion. Kibem, you might agree or disagree.
Yes, I think those people who wrote the Constitution, I don't think any lawyer who has ever drafted a petition was asked about these timelines. Because I don't even the period for even filing the petition should even at a minimum, the very barest minimum, in my view, should be 21 days. Because if for an election that is just for a member of parliament and MCA, you have 28 days, how do you now in 290 constituencies and about 1,400 or something wards, do you get all this evidence and you do a good job? Of course, people are in a hurry that, you should challenge it as quickly as possible, but that now has come at the expense of a fair dispute resolution. But the key issue that we have not told you as yet is that this hearing is likely to proceed up to the 12th or 13th day. There is a very high possibility, particularly if you have more than one petition, meaning that the Supreme Court on the 14th day will decide that we have dismissed the petition or we have allowed the petitions. But on that particular day, there will be no judgment that will be read in court. Remember that a judgment is where you give the reasons that we had this evidence and this is what we have decided. So you give a decision on the 14th day, then you say come after 2 weeks to hear what are our reasons. Ordinarily, and every day when we go to court, even for lawyers, it is very unusual that a decision is being given and the reasons for that decision, which is now the purpose of the judgment, are not being given on that day. And remember, it is important I say that. If, for example, you said that you are nullifying an election, and you've just come here 7 people or 5 people, and you are judges, and you have said you have nullified the elections, come for the reasons why we have done this after 2 weeks. It's like an anticlimax, because everybody would be asking, why did you do that? Yet the rules that we have made, and that is exactly what will happen. And therefore I don't think that these rules are fair. You don't think these rules are fair? Thank you for answering that. I'll give each of you a final question, some from our viewers. I'll give you 30 seconds because we're not doing too well on time. I wish we had 2 hours. Clearly, we need to call you gentlemen back. Maybe let's see if next Friday we might come back and do this again. Although, of course, to be a bit more sensitive now because the matter will actually be quite close to the Supreme Court, and there are certain things we can't talk about. Apollo, you'll answer someone's question here. You just remember it because I want to give each one a question. Someone is asking, you don't tell us your name or where you're texting from. What if petitioners file fake documents? And are there chances of Kenyans going back to the ballot? That's a question for you. For you, Akusala, this is Jack Mwaura from Mudhiru saying, can the court dismiss the petition at a preliminary stage for lack of evidence presented? Okay, you've got that. And for you, Kibe, someone else is asking, how are courts, both in Africa and around the world, watching this petition? And what do you think their take is on this? Because I'm sure courts all over the place always borrow from other courts in other countries. I think in 2013, we were told that our Supreme Court also looked at, was it Nigeria and somewhere else as well? So now, are other courts now benchmarking themselves with what's happening here? Let's start with you, Apollo.
Yes, if they file fake documents.
Yes.
Any person who alleges that a document is fake must prove it, okay? And any person also who wants to rely on a document must also show where they got it from. So that is a question that will be before the court, and it will be argued. Yes. And can we go back?
Are there chances of Kenyans going back to the ballot?
Of course. The Constitution actually envisages that. Yeah. In Article 140. That you can go back.
Akusala, over to you.
Preliminarily, dismissal of the petition.
Yes.
As long as the petition has met the thresholds, it will be hard to its determination.
Okay.
The only thing that the court may decide preliminarily dismiss or allow are interlocutory applications, but the petition must be decided and reasons given as to why it is dismissed or allowed.
Okay.
Yes.
Okay. And for you, Kibe?
Yes, how other courts are watching this petition?
Yes.
Of course, the many courts and our many lawyers, let's put it that way, other countries are watching us. And they're watching us, for example, you see where a lot of observers were sent to come and witness how this electoral process is going on. I believe most of the observers will still be watching the space to see how now the disputes arising from these elections are being resolved. Of course, the key issue for many courts and lawyers would be the judgment that ultimately comes out of this process. How is this judgment? How does it measure up? The last time it was said that, and there was a dissatisfaction from both sides. The people who won the petition actually said that the judgment was not good enough even to represent their will. Of course, the people who lost had even more trouble with that particular judgment. So personally, as a lawyer, because I am one of the people who will be watching this, I hope that a high caliber judgment will come out of this dispute that will be presented in court. And of course, I'm expecting, like the last time, that the lawyers are going to present very good arguments. Courts in deciding cases also refer to other cases that have been decided in other courts on similar issues. So it is bound to take place, and that is now when people will be filing submissions. You've had people talking about submissions.
Yes.
They will be saying on a dispute like this in the other country, this is what their court decided, and it can persuade the judges to have that view of the law.
I'm going to cut you off there. I had said those were my last questions, but so I've gotten to them. I'm going to try and there are many more coming in.
Yes.
Maybe I'll give them over to you and we'll figure out a way of how we can answer them. One person asks, if the election is nullified, Who will be the interim president for 60 days? Please answer in one. Whoever will answer.
Just Uhuru Kenyatta.
Uhuru Kenyatta.
Okay.
Continue. Uhuru Kenyatta. Thank you. This you don't tell us your name. You ask. And finally, what are the consequences, financially or in any other ways, of losing a petition?
Okay. If you lose a petition,
yes, in 10 seconds.
In 10 seconds.
Yes.
Those security of cost, which Advocate Kibi had told you about.
Yes.
There is a potential that it will go to the person who has won in that.
So
there are potentially financial consequences.
Yes, but it could be more.
It could be
more. And particularly if the award of course is given, because of the size of the case and the magnitude of it, I do not see a situations whereby you would be paying less than 10 million as costs in this kind of matter.
But also it is also possible
10 million. Sorry, that is mind-boggling. Go ahead. Kusala?
That court may agree that this is a matter of public interest, and therefore each party bears their own costs. So the only cost to be borne are advocates' costs.
Okay.
Yes.
Of course. You
my other friends we are not ruling out. There may be advocates like Apollo here may decide to offer his services pro bono.
Okay.
So we are not ruling that out as well.
Okay. Yes. Well, that's how we wrap up this part of the broadcast. Gentlemen, thank you so much. Kibe Mungai, Boniface Akusala, Apollo Mboya, for taking time to help us here on Presidential Petition 101. We've written lots of notes here. I hope I've written the right things. I've seen somebody asking, Wahiga, hiyo handwriting ni ya nani? I won't answer that for now. We take a short break into the second hour of Citizen Extra. We'll be talking about how does the world view Kenya in light of what has happened over the last 2 weeks. We had an election, we had protests as well. There's a lot that's been happening. We'll be taking a look at what global media are saying about Kenya, and we'll be talking to some people who've been looking at the global stage and trying to figure out what does the world think of Kenya at the moment. That's our discussion in the next hour. And of course, we'll be crossing over to the different counties where inauguration ceremonies are taking place and giving you snippets and highlights of what is happening, whether in Muranga and Kajiado and some of those other locations where the governors, governor-elects, or even incumbents who got another chance are being sworn in today. You're watching Citizen Extra live on Citizen TV. We'll be right back.